Hello and welcome to Regional Counsel, presented to you by the Singapore Academy of Law. My name is Nicole and I am your host for today. Regional Counsel is a series of short video podcasts on legal content catered to in-house counsel who are new to ASEAN regional work. This series is not meant to be a deep dive, but to equip in-house counsel with tips and tricks from experts to navigate the challenges faced when dealing with jurisdictional specific quirks. In today's episode, we will be delving into Indonesia law with an expert, Associate Professor Gary Bell of the National University of Singapore. Hello, Professor Bell. Thank you for joining us today from Canada. Okay, Professor Bell, could we just quickly ask you about the corporate structure in Indonesia? So we're just moving on to the next topic. Yeah, just to understand a bit more about incorporation.
I'm not I'm more of a contract law person than corporate law person, but I do know quite a bit about the corporate law from the cases that I have.
Certainly more than us. So it would be good. It would be good if you can
And I
share.
also teach it to my students, so I do have to read about corporate law in Indonesia. But basically, it's again continental European style, right? It has two boards, a board of director and a board of commissioners.
Okay.
And that's not unusual. And that changed in many places, but it's difficult sometimes to understand if you come from a common law country, right? But think about it as, in principle, I'm going to talk after how it works in practice, which might be quite different. But in principle, what it is you got a board of director, which is basically your board in the common law, right? The one that administers, decides things in between shareholders' meetings. And you've got a board of commissioners. So the role of the board of commissioner is to actually supervise and make sure that the board of the directors does its job.
I see.
And in principle, it can call a meeting of the shareholders to dismiss the board of directors. This was an invention of independent director way before the common law started talking about independent directors. So this is an interesting structure. The problem is the way it's structured in Indonesia, and my friend Dan Puciak at SMU and others, his colleague in Indonesia, Nathaniel, and others have written about this. Most of the companies in Indonesia are either conglomerate or a family-owned business, and therefore there's always a majority shareholder. So it's not a dispersed shareholding as you have seen in the United States, for example. And in that context, the shareholders appoint both the board and the board of directors and board of commissioners. They're not going to be that independent, right?
Yes. Yeah.
They're all going to be appointed by the majority.
Majority,
So
yes.
the function doesn't function very well, right?
Okay.
It's supposed to be, policing the board of directors, but it's not. But the structure is like that. And then after the financial crisis, the Asian financial crisis, 97 to 99, right? The IMF and started saying you have to have independent directors. But the Indonesians said, well, we have a board of commissioners. But then nonetheless, they changed their laws, not the company law, but the law for public traded companies to say that they had to have independent directors. But interestingly, they took that away. It's the first country I know that took away the independent director requirements.
I see.
In part because we have two boards, but there's a problem. It doesn't really work very well. And I'll add one thing. You can also have a third board.
Third
which
board,
is
on
very
top of the
unusual.
board of commissioners and the board of directors.
Yes.
Wow.
Yes. But this is for companies that actually have Sharia, Islamic goals, right? So then they would have a Sharia supervisory board to make sure that the transactions follow the Sharia. That there's not going to be any alcohol. They're not going to, right? So they're not going to use interest. This is a board that certifies the basically halal character of all the transactions.
Okay.
So this is a bit of the structure of the company.
Okay. Thank you so much for sharing that. It gives us a bit of a taster of how Indonesian corporate law is like. Could you also share with us?
But can I just say that on that, there's much more written in English.
Okay, Professor Bell, could we also share? Could we also hear from you about your experience sitting as an arbitrator on tribunals, especially in contexts where the governing law of the contract is Indonesia, but the seat is in Singapore? I think most of our listeners will probably be listening from Singapore, so I think your perspectives from the tribunal would also be very useful.
Yes, I've done quite a few of those. It's always quite interesting, and the difficulty usually is the law. You often have people who are the lead counsel are often from common law jurisdictions, and they have to apply civil law. They have, of course, lawyers, Indonesian lawyers assisting them. But the difficulty is often the argument on law becomes difficult when the law is so uncertain, right? And getting the right expert is also difficult. Sometimes a recourse to Dutch lawyers can be useful in terms of not binding, but we interpreted that provision this way in Holland, right? And if you say this same way in France, so sometimes looking at other jurisdictions can be helpful when you don't find any case, and it has happened to me repeatedly. When I say, well, is there any case in Indonesia or any doctrine, any writing by law professor interpreting this article of the code? People say no.
Wow.
So we really looking for, you can try from first principle, this article, how does it go with the rest, etc. But sometimes it might be helpful to look outside, right? The other thing to know in all that I said about I mean, of course, in arbitration, there's no rule of evidence, no national rules of evidence. So either the party agree to a set of rules or the tribunal decides how to apply the rules. But still, you have to interpret the contract. And if the contract is governed by civil law, it means looking at negotiations, etc. Right? So that's one thing, unless the parties agree otherwise, right? And that's one thing to take into account. The other difficulty is the parties should be aware of that from the very, I mean, at least at one point during arbitration, is that enforcement of arbitral awards in Indonesia, the registration of the award, according to the law, must be done by the arbitrators.
Oh, okay.
Which is weird.
Yeah, that's weird.
Right?
Yeah.
That's weird. So the solution to that is to ask for power of attorney. But so that the lawyers can do it instead of the arbitrators. But you have to do it while the arbitrator is still an arbitrator,
Yes.
right? After the sentence, people come after, okay, I'll sign it, but I'm no longer an arbitrator. I mean, the case is over, right? I don't have any power anymore. So, but it's difficult. I know they need that. But if I suggest to a party that they ask for that, it looks like I'm favoring a party.
Yes, that's right. Yeah.
So it should really come from the party. They should be aware of this potential difficulty, right?
Okay.
So that, and there's many more things I should say as well. But in this one, I can recommend one of my articles. Right?
That would be great. Yeah.
Yeah, I gave it. This is exactly what I talk about: conflicts of law and jurisdiction in Singapore, in Indonesia-related arbitration. So it could be a reference. It's not extremely helpful article, but it might be helpful.
Yes, Professor Bell, could I just pick your brain about investing in Indonesia? So I understand there's a regional autonomy law. Could you share with us a little bit more about that? If it's something that you think it's worth in-house counsel noting.
Yes, it's certainly worth noting the developments in regional autonomy law. A law was adopted in 1999, referred to as the Big Bang, because it was by law, and the law came into force in 2001. By law, so many powers that were with the central government were decentralized to the region. But it was I'm sorry to say, it was a bit of a mess, right? Because the regions were not ready. They didn't have there was also a conscious transfer of funds as well, but the funds did not correspond to their responsibilities. Regions started taxing And they taxed in ways that the central government lost control. And therefore, investors were not happy because this region suddenly, when they made the investment, they knew how much taxes they would pay to central government. Now the region asked for more tax. So there was a lot of problems. There was a lot of problems, which led to reform of the law repeatedly that tried to either make clearer what kind of taxes they could charge, right? Also make clearer how conflicts will be solved, but also re-centralize a lot of powers. Most investors want to deal with the investment coordinating board, right? This is how they changed the name recently, but basically the government office that approves the investment, right? So you want that, and then you hope that from that all the permits will follow, right? But the problem with regional autonomy is that people were asking, the regional government were asking for this permit, that permit, and now their omnibus law, which was adopted 2 years ago, this omnibus law actually re-centralize some powers and it does make it easier for investors. So it's not perfect. And the reason I'm saying all this is you have to take into account the region where you invest. You have to start a relationship with that government as well. If you're going to have a mine in eastern part of Indonesia, you shouldn't invest after just talking to ministers in Jakarta.
Yeah, that's
Go
prudent.
there, go talk to the government, go talk to the regional government, get to know the region. I mean, I think most big investors know that, right? I'm not teaching anything to investors, but it's particularly important in Indonesia because the regions are often fair. I mean, I'll be fair to the region. They've been exploited by the center, right? The government, I mean, the very rich mining regions didn't get anything. Aceh, Sumatra didn't get richer from all the oil that was exploited from there. The central government and the Suharto family got rich and Java got rich, but the region where the resources are. So now they want the investment to favors them as well, which I think is fair.
Yes, of
Right?
course.
So I think investor can understand that. It's a matter of saying to the central government, yes, you're taxing me, but but the problem is the uncertainty. When decentralization was done, the minister in charge of decentralization at a conference I was at was asked by someone, will this lead to decentralization of corruption? And he says, yes, it has already happened. So there's a problem. In Suharto, when you invested, you went to Suharto and said, I'm going to take 10%. That was it. Everyone below was paid by Suharto and ordered by Suharto and obeyed Suharto. It doesn't work that anymore. It's a democracy. You've got regional government, you've got a governor, you've got a bupati in every region, and you've got to take into account you put these people on your side.
Yes, for sure. Yeah, and Indonesia is a big country, so I think Council should be very, very alive to the fact that it's a big country. There are many regional governments and they ought to be consulted as well.
Yes, that's right.
Thank you so much for sharing that with us, Professor Bell. Is there anything else that you would like to share, to our in-house counsel before we wrap up this podcast? Any tips or tricks to navigate the jurisdiction, this particular jurisdiction that you've not already covered?
I will say one thing that yes, there are some negative aspects I mentioned, right? Let's be frank, there are some negative aspects in Indonesia. However, people are very friendly.
Yes.
People are very willing to listen. Access to government is incredibly easy. People are always willing to talk in ways that is it's amazing. I write the Chief Justice of the Court of Indonesia. I have 10 students who want to see you. Yeah, sure. And he comes and talks to us, right? There's an access to government, which is very easy. And that's, I think, some investors have mentioned to me, okay, it's slow, but people are listening, friendly. You have to keep the relationship. It's a very Asian thing, right?
Yes, it's a very Asian thing.
But it is a very important aspect. And I think, if I may say so to our Singaporean friends, we lose that aspect sometimes a little bit in Singapore because we're so used to efficiency
Yes.
and not thinking of how is your brother, how's your wife, she was sick. These kind of things that build relationships are very important in Indonesia. Whether you deal with Chinese, Indonesian, or Pribumi, indigenous Indonesian, this is very important, the relationship. And they're happy to have a relationship with you. They're
Yeah.
not anti-foreigner, right? So the, it's a very pleasant place in many ways, notwithstanding all the difficulties.
Thank you so much for sharing that, Professor Bell. I think relationships are important for anything. I mean, especially in Indonesia, in my experience as well. Yeah, and as you shared earlier on, the Indonesian legal system prides fairness, right? You mentioned equity
Yeah.
is essentially fairness and good faith. And that's something that, it's important for in-house counsel to note for when dealing with Indonesians. I mean, we don't have to have long, lengthy contracts spelling out everything because everything turns on the relationship, the intentions of parties, and yeah, all these things that you have detailed to us earlier on, which has been very, very useful. So thank you so much for spending some of your precious time with us. Really appreciate you, especially calling from Canada. It must be very late right now. But we really appreciate you. And yeah, so for listeners, Professor Bell, it's at the National University of Singapore. He's written extensively in this area. And so thank you so much, Professor Bell, once again.
Thank you so much. My pleasure. Bye bye.
Thank you so much, Professor Bell, for joining us on Regional Counsel. If you have found this episode helpful, please check out the other episodes. This has been Regional Counsel, a production by the Singapore Academy of Law.